All right, I'm going to go ahead and get started so that we can make the most of our time tonight. Good evening, everybody. Welcome to the 2021 Memorial Beecroft Lecture. This is an annual lecture series at the UNLV William S. Boyd School of Law and its Sultan Center for Conflict Resolution. My name is Lydia Nussbaum. I'm a member of the faculty here at the Boyd School of Law and also director of the Sultan Center. And I have the pleasure of serving as MC for our program this evening. So tonight, our distinguished speaker is Professor Martha Minow. She is the 300th anniversary university professor at Harvard Law School. I'll introduce Professor Minow more thoroughly in a few moments. But first, here to say a few words about our law school and the Sultan Center is our Dean of the Law School and the Richard J. Morgan Professor of Law, Dean Daniel Hamilton. Dean Hamilton.
Thank you so much, Lydia, and thank you for your terrific directorship of the Sultan Center. It's a great pleasure to welcome everyone here tonight for the annual Beecroft Lecture. This is a great annual event supported by the Sultan Center for Conflict Resolution, and prior speakers in this series include University of Pittsburgh Law Professor Pat Chu and UCLA Vice Dean and Law Professor Russell Korobkin and Marquette University Law Professor Andrea Schneider. And it's a particular pleasure tonight to welcome Professor Martha Minow, 300th anniversary university professor and former Dean of Harvard Law School, who joins us tonight for this timely and important talk. Professor Minnow is one of the great scholars in legal education and is a leading expert in human rights, transitional justice, and advocacy for members of racial and religious minorities and for women, children, and persons with disabilities. She writes and teaches about all sorts of things, including digital communications, democracy, privatization, military justice, and ethnic and religious conflict. It's a great honor to welcome her tonight as part of the ongoing programming of the Sultan Center. The Sultan Center brings this annual event to the school every year. The center was founded in 2003 at Boyd and is designed to serve as a forum for the advanced study of conflict and how to resolve it. It is every year one of the top ranked dispute resolution programs in the country, about which we're very proud. The three-part mission of the Sultan Center is to stimulate scholarly research and discourse that is led by our nationally recognized faculty in this field, particularly Jean Sternlight, of course, and Lydia Nussbaum. Secondly, to provide our students and the public with education in dispute resolution and methods, and to facilitate resolution of public and private sector conflict through our mediation clinic, which Lydia directs, and of course, our public events like tonight. Tonight's Beecroft Lecture is really emblematic of the Sultan Center's mission, a public center for discourse and a way to engage some of the most pressing issues of our time. And we're very much looking forward to Professor Minow's remarks on restorative justice and anti-racism. A special thank you, of course, to the founders of the Sultan Center, Michael and Sonia Sultan, for their tireless energy, support, and vision, all of which makes the Sultan Center for Conflict Resolution possible. We thank them, of course, for making the Sultan Center Professorship possible, which is held by our own Jean Sternlight. I also very much want to thank the alternate dispute resolution section of the State Bar of Nevada, which has made tonight's lecture possible through their support of this lecture series in memory of the late Chris B Croft Jr., a much beloved colleague and former ADR commissioner here in Nevada. Chris Beecroft was a member of the State Bar of Nevada in private practice for 25 years, and as ADR commissioner, he really developed and monitored a collection of dispute resolution programs throughout the 8th Judicial District Circuit and led the creation of the short trial program, which has itself received national recognition. We're grateful to the State Bar and to the Beecroft family, and this lecture series is a tribute to his legacy. I do want to recognize the Beecroft family that has joined us here tonight, particularly Christine Beecroft, who is tuning in from Las Vegas, and their children who are tuning in from around the country. I always want to recognize Jean Sternlight, the founding director of the Sultan Center for Conflict Resolution, for her leadership and all she's done for all of us at the law school and in this field around the country. And of course, our distinguished speaker, Martha Minow. And I also want to thank Margaret Crowley, who is a great mediator herself, of course, from Reno and chair of the ADR section of the State Bar of Nevada. And I'm proud to say a adjunct professor at the UNLV Boyd School of Law. So with that, I will turn it over to Margaret Crowley, who will talk more about the ADR section, the Beecroft lecture series, and Chris Beecroft. So Margaret, thank you.
Thank you so much, Dean Hamilton. Good evening from a very windy Reno tonight. As chair of the State Bar's Alternative Dispute Resolution section, I'm delighted to welcome you to yet another presentation in our ongoing B Croft lecture series. The ADR section is so honored to partner with Sultan Center and Boyd School of Law once again on this series. These wonderful lectures serve to further our section's mission to conduct, assist, and encourage public and professional ADR education programs. Not only are we accomplishing our mission tonight, we are also honoring a man who was so instrumental in creating and growing ADR programs in our state. Chris Beecroft was a graduate of UNLV and of McGeorge School of Law. I would note, this was before Boyd came into existence. Over the years, Commissioner Beecroft, as Dean Hamilton mentioned, wore many hats in the 8th Judicial District Court. He served as its ADR commissioner, as administrator of the short trial program, and discovery commissioner for the family court, and several other departments in the 8th Judicial District. In 2006, Commissioner Beecroft received the Better Government Award from the Pioneer Institute for Public Policy Research. Pioneer is a good word to describe him. The ADR section membership has been growing steadily, and in fact, we've reached a record number of members this year. It's people like Commissioner Beecroft, those who work so hard, not for power or for glory, but for passion, who lay the foundation for successes such as this. Those of us who practice in the ADR field or who use ADR owe him such a debt of gratitude, and we are honored to have his name as part of this superb speaker series. I am certain he would be excited by the growth of ADR in Nevada, and so pleased to have Professor Martha Minow presenting on such a critical and timely topic. And once again, we are very happy to welcome the Beecroft family who has come to this lecture every single year. We are grateful for everyone's support. We hope to continue this lecture series for years to come. Again, welcome and please enjoy the lecture. And with that, I will turn it back over to Lydia Nussbaum.
Great. Thank you so much, Margaret, and thank you, Dean Hamilton, both of you for your words this evening, and as always, to the ADR section of the State Bar of Nevada for its continued support of this important lecture series. So for those of you who are just joining us, again, my name is Lydia Nussbaum. I'm a professor at the UNLV Boyd School of Law and director of our Sultan Center for Conflict Resolution, and I have the distinct honor of serving as MC for tonight, which also means I have the honor of introducing tonight's distinguished speaker, Professor Martha Minow. And I would like to say a few words about her because I want to reserve as much time as possible for her to talk and for your questions at the end of the program. And although my aim is to be brief, it's hard to do that for someone with such an incredibly prolific and impactful career as Professor Minow has had, but I will try. So Professor Minnow completed her undergraduate studies in history at the University of Michigan, graduating magna cum laude. And then she went on to receive a master's degree in education from Harvard, and then her law degree from Yale Law School. She clerked for Judge David Bazelon at the U.S. Court of Appeals for the D.C. Circuit, and then for the United States Supreme Court, Justice Thurgood Marshall. Professor Minnow accepted an offer to join the faculty at Harvard Law School in 1981 at the ripe old age of 26. And in addition to an exceptionally productive academic career over the years, she also served as dean at the Harvard Law School from 2009 to 2017. So Professor Minnow's scholarly footprint is immense, large shoes indeed. She has authored and co-authored more than 276 articles and books. And as Dean Hamilton mentioned, her work explores a wide range of substantive areas of law, constitutional law and the First Amendment, education law and policy, human rights, transitional societies, law and inequality, law and social change, nonprofit, non-governmental organizations, cyber law policy, the internet, and of course, privacy law issues around algorithms and fairness. And she explores this wide range of interests using an interdisciplinary and comparative and humanist approach. So while the scope of Professor Minnow's scholarship is truly immense, it does orbit around a central theme of social justice. And within that, some clear themes emerge from her work, and I'm just going to highlight a couple of those as they're related to her remarks tonight. So the first is her work emphasizes the importance, in fact, that it's essential to acknowledge that very real differences exist among individuals in society, differences between men and women, between individuals with different religious, ethnic, and racial identities, between persons who live with a disability and those who are non-disabled, and that these differences pose fundamental challenges to the functioning of a democracy, and that these challenges can often result in injustice. And relatedly, her work explores how social institutions, especially the law and our legal institutions, respond to such injustices. And her work explores how, our legal system may do a great job of enabling the resolution of certain disputes. It lacks the capacity to cultivate understanding. And that's understanding between individual disputants, but also all the way up, to the macro level, the societal level, and disputes between groups who may be in the throes of bitter and violent conflict. And this area of her work has led to extensive examination on the utility of vengeance, but also of forgiveness as a tool for enabling this need for greater understanding between individuals and groups in conflict. And so this, of course, leads me to the topic of Professor Minnow's talk tonight, Restorative Justice and Anti-Racism, a topic that couldn't be more relevant, especially on a day when jury selection was scheduled to begin in the George Floyd murder trial. And as we see the questions about the ability of our legal system to address injustice, to bridge understanding unfolding in front of our eyes. So I will yield the floor to Professor Minnow in a moment. She will speak for about 30 minutes, and the remaining time tonight is reserved for Q&A. You're welcome to post your questions in the Zoom Q&A feature. That's the only way to post questions in tonight's program. And after Professor Minnow concludes her remarks, I will read and select as many questions as I possibly can in the time we have remaining for Professor Minnow to answer. So without further ado, Professor Minnow, thank you so much for being with us tonight.
Well, thank you, Lydia. That was just beautiful. And I learned a lot as well. Thank you to Dean Hamilton, to Margaret Crawley. Thank you to the ADR section of the State Bar. Thank you, Jean Sterlite. And thank you all who are here to remember and honor Chris Beecroft, to Christine Beecroft, who pioneered and administered innovative conflict resolution methods, and to other members of his family. Thank you to Michael and Sonia Saltman for the vision behind this world-class center. And thank you to my old friend and colleague, Tom Main, and to the wonderful Boyd School of Law community, extended through Zoom to friends and others around the world. Conflict resolution. We need conflict resolution. The belief that we are divided is perhaps one of the few things that Americans right now have in common. Is forgiveness, letting go of justified resentment, a way out? Should the United States create a Truth and Reconciliation Commission to heal our national divisions? Should pandemic era debts be forgiven? Should the protests after the killing of George Floyd lead to punishments or to forgiveness? Some people during the protests last summer revived the 1968 Kerner Commission call for massive investment in poor communities and policies to tackle structural racism. That report reasoned that white racism and pervasive inequities, not anger by African Americans, caused the turmoil in the streets. The report went unheeded, and ironically, that report, now more than a half a century old, itself called out the failures of prior reports looking at racial conflict in this country to achieve any traction. In the midst of the protests last summer, some white police officers asked members of the Black community for forgiveness. The contrasting behavior of law enforcement during those protests and then the January 6, 2021 assault on the US Capitol prompt new questions about blame and forgiveness. Many of the fervent statements of support for Black Lives Matter, statements by corporations, nonprofit organizations, schools, religious communities have now faded as the crises of each day unfold. Meantime, many in poor and predominantly white rural communities feel abandoned or disrespected. National divisions and distrust, collective amnesia about past collective amnesia, growing economic inequalities revealed and exacerbated by COVID-19, inequities in law enforcement and structural divisions. It can all seem overwhelming and surely larger than any one person can tackle. This is, however, our context, and I hope that by addressing restorative justice and racism and anti-racism together, there may be some lessons that can help us. Restorative justice refers to responses to harms and wrongs that focus on repair rather than punishment, that promote encounters and cooperative meetings among those harmed, those causing harm, and other willing stakeholders to discuss what happened and try to do something about it. Restorative justice processes explore potential consequences and actions that respond not only to past harms, but also to transform individuals and relationships and communities, to remedy deeper injustices and prevent future harms. In the United States, the biggest support for restorative justice has arisen in criminal and school discipline processes, often dealing with young people, but its potential exists for all age groups and for varied harms. Rooted in traditional and indigenous practices in many parts of the world, restorative justice programs have been growing and attracting support, including from the United Nations and other international bodies. And some of the programs specifically address mass incarceration in the United States. So police departments and prosecutors, courts, religious and other nonprofit groups are exploring and using restorative justice. These efforts respond and build on mounting evidence that mass incarceration has little or no effect on crime, and some research showing how constructive social engagement, stimulating environments induce positive changes in the circuits of the brain, affecting empathy and emotional regulation. Some programs offer complete alternatives to the formal criminal process or school discipline process, while others work alongside those more formal mechanisms. Here's an example. In 2019, a man named Michael Lee sat down with the son of a beloved philosophy professor, Young Kim. Lee had killed Kim and now sat with his son and others as each recounted from different perspectives the story of the professor's death and its effect on those who had loved him. Matthew explained how it was a mugging gone wrong. He tried to grab cash from the professor who had just made a withdrawal from an automatic teller machine. Lee pushed the professor, who fell down, hit his head, and later died. The prosecutor charged Lee with a felony murder because the death occurred in the midst of a robbery, and that crime could carry 15 to 25 years in prison. Lee, in this session, explained that he had never previously committed a crime. He was desperate, out of a job, behind on rent, about to be evicted. The victim's son talked about his sadness that his own daughter would never get the chance to meet her grandfather. Mr. Kim's daughter-in-law said her father-in-law had hoped to write a book entitled Small Happiness, and that he would never be able to write that book. Meantime, the offender's sister discussed missing her brother since his arrest and incarceration. Lee, the offender, apologized and thanked those who came, and he said the following: "To have to bring everyone together right now and see everyone cry and shed tears, it's going to stick with me for the rest of the days of my life." The victim's son explained that his family had chosen to come to the restorative circle, and I quote, "And I think having made that decision, having This opportunity to talk to you and hear that you're sorry, it will probably make me heal more than anything else. The hurt may never go away, who knows, but the hate I can control. Learning about this session, Manhattan District Attorney Cy Vance offered Lee a reduced plea to the charge of manslaughter and a sentence of a 10-year prison term. At the sentencing procedure, the victim's son appeared and said to the defendant, "I am grateful that you had the strength and courage to do the right thing afterwards. You confessed, accepted responsibility for your actions, and apologized to my family deeply and repeatedly. I am glad that I heard your words directly, not filtered through lawyers. I believe you when you say you are sorry and that you will do your best to stay out of trouble in the future." These insights align with the research of the developing field of positive criminology, which focuses on factors that discourage or prevent criminal conduct. Key elements are strengthening social bonds and developing empathy and stress management skills. Restorative justice thus can supplement existing criminal justice or offer alternatives, and especially in the school context, restorative justice offers training for the whole community. The whole school approach tries not only to address existing conflicts, but also to prevent conflicts from erupting. A key technique uses non-hierarchical communication, bringing together students and staff, community members to sit together in circles and speak directly to one another using mediation techniques, promoting accountability and making amends. School-based programs integrate conflict prevention and resolution into classroom teaching and learning about the consequences of one's actions and about what it means to take responsibility. In practice, though, this ambitious vision often falls short of the ideal. Indeed, Professor Nussbaum and others have demonstrated that. But at its best, restorative justice means attending to the deeper causes behind conflicts and strengthening the capacities of individuals and whole communities, both to deal with erupting emotions and to resolve disagreements peacefully. Consider this example from a few years ago. A young woman named Mercedes M. enrolled in a California high school after she was suspended for too many fights in her previous school. And as two classmates at her new school called her a liar and a thief and the B word, an altercation came to the attention of a facilitator who took Mercedes aside. They talked one-on-one, and the facilitator learned that Mercedes had in fact stolen the shoes of one of the other girls, but also learned that Mercedes and the two girls had known each other for years and had many previous intense disagreements and no better way to communicate. The three young women agreed to attend a circle, a confidential conversation facilitated by a trained leader, and there they all expressed anger. But then Mercedes apologized. She also explained that she had stolen the other girls' shoes in order to sell them to help pay for a drug test for her mother. If her mother could prove to the court that she was clean, she might persuade the state to return Mercedes' younger siblings home from protective state custody. When the other girls saw Mercedes cry, they empathized and they gave her a hug. They didn't ask her to replace the shoes, but they said they wanted a restart and an assurance that going forward, they could trust her. Mercedes later said that without this process, she's sure that the conflict would have escalated and she probably would have been suspended or expelled. And this kind of experience is one of many. In her own school, in Mercedes' school, with the help of restorative justice circles, school suspensions have been reduced by half. Comprehensive restorative justice approaches help not just students, but also staff and faculty learn to manage their emotions and diffuse or avoid conflicts. And restorative justice alternatives can actually help people in schools and in the criminal justice system have honest conversations and devise reparative steps. And some programs specifically attend to trauma, and trauma not only of those who have been harmed, but also those who have caused harm. Racial justice reforms motivate both restorative justice initiatives and criticisms of restorative justice. The disproportionate effect of criminal law processes on communities of color is mirrored by the disproportionate effect of public school disciplinary processes. The possibilities of something less punitive and more forward-looking can serve the interests of racial justice. Fania Davis, a leader of restorative justice, argues powerfully about its promise for racial justice in America. From this vantage point, racial justice is a good and should be more equitably available to people of color. And yet, there are risks of racial inequity in the use of restorative justice. And there are criticisms of it from that vantage point as well. One of the big sets of criticism echoes criticisms of alternative dispute resolution, that the informal nature of restorative justice warns some risks exacerbating pre-existing power relationships between parties. 20 years ago, Richard Delgado published an article entitled "Goodbye to Hammurabi," analyzing the atavistic appeal of restorative justice. And it extends a critique that he and others had developed of ADR, alternative dispute resolution, as bypassing the checks on abuse of power and bias that's afforded by a formal system and by public audiences and by precedents and the legal rules. What happens in closed doors, in mediation, and in civil disputes or restorative justice circles warned Richard Delgado and warned many others, that needs discipline, that needs the formality of the rule of law. Restorative justice focuses on specific people, relationships, and plans for future action, but then leads to inconsistencies rather than equal treatment. Such inconsistencies could negatively affect members of racial and ethnic minorities. Participants may face the attitudes of a particular facilitator and not have the guardrails of the former rules. Even well-intentioned practitioners have racial biases because we all do, and they may lack the ability to counter those biases. Research into implicit bias suggests that mediators of any race lack neutrality despite good intentions and commitments to fairness. Another kind of criticism challenges the brief time that's devoted to building relationships or rebuilding them in restorative justice conversations. One conversation in the shadow of a criminal sanction just doesn't cut it. And even in schools that have longer term restorative commitments, relationships can be fragile and governed by emotion rather than rules. Imbalances of power and a perpetuation of racial bias. This is another kind of problem. In the Australian context where restorative justice has been much pioneered, Kathleen Daly examines inconsistent views across police officers and coordinators of conferences and finds inconsistencies that harm members of the minority community. She also exposes how, whatever the intention, the restorative practices themselves are saturated by racial and ethnic divisions and historic attitudes. There's one more kind of worry about restorative justice and racial justice. People of color may be expected to forgive or even pressured to do so more than is true for white people. Restorative justice may seem like a lesser, cheaper response to Black victims when compared with criminal prosecution. And expectations of forgiveness too often accompany those with less power. Restorative justice as practiced today may also fail to address systemic harms. And like ADR, restorative processes do not offer structures for collecting many similar claims in the same action. Restorative justice itself may be mistaken in imagining it's a reestablishing of some earlier better days when, with regard to race relations, there may never have been better days in particular communities. And restoration may seem to bolster the status quo that contributed to the conflict in the first place. Groups that develop special expertise and create credentials in restorative justice may, in fact, install criteria that disfavor the lived experience of people of color. And the lack of diversity among restorative justice facilitators has been observed by many people. Meantime, as with ADR, the focus on flexible processes and individual remedies could extend the power of the government, even further into the lives of individuals. Think about the catch-22 facing Mercedes' mother, or the causes of Lee's poverty. The underlying causes of conflicts, if really attended to, deserve attention. But the availability of restorative processes may seem easier and more attractive and lead people in positions of authority, teachers, police officers, to refer people to the system, when in other instances, if only formal process was used, they would not do so, and therefore would not draw people into the surveillance control of the state. There is not as much evidence empirically about whether any of these risks are real. There's not much evidence, in fact, about the benefits or the harms of restorative justice. There's some, and some limited ones that are promising. But as a result of the vacuum of really solid empirical evidence, there's a lot of debate. And the debate actually doesn't really shed too much light. I think that it's time to ask of this reform or any reform, compared to what? Defects in restorative justice must be contrasted with the problems with the traditional criminal justice processes. And even assessments of restorative justice that reflect dominant practices have to be compared again to what? Rather than asking, is it working? We should be asking, in part, who working for whom? And it's in that context that it seems to me worthwhile to actually shift gears for a moment and talk about the racial justice movements in this country. The civil rights movement of the 1950s and 60s and some more recent civil rights initiatives offer some instructive lessons for restorative justice. The civil rights movement that assaulted Jim Crow segregation, for example, deployed direct action, boycotts and marches and other protests, as well as litigation and empirical research. Contemporary racial justice movements use media and narrative and visual arts, as well as internet networking, to mobilize and highlight patterns of racial hierarchy and press for desired changes in policies and practices. Current anti-racist work includes lobbying public and private actors and implementing trainings and skill building workshops that actually work at the interpersonal level as well as the institutional level. Confrontation and direct is another tool for racial justice, and it's at odds with the conflict resolution approach of ADR and restorative justice. What about the possibilities of a both and approach that uses, where possible, relationship building, negotiation, and storytelling on the one hand, and confrontation, and certainly challenge to systemic racism on the other? It turns out that longtime restorative justice visionary Fania Davis has a sister, and her sister's name is Angela Davis. Angela Davis, well known as herself a civil rights leader and an anti-racist activist for decades. It turns out that the two of them have found something of value in each other's work. In a dialogue with her sister about restorative justice, Angela Davis observed, and I think that now we're thinking deeply about the connection between the interior life and what happens in the social world. Even those who are fighting against state violence often incorporate impulses that are based on state violence in their relations with other people. Is it possible to draw on the insights of interpersonal work that restorative justice attends to actually get more deeply at the roots of ongoing racial injustices? There are promising initiatives of this nature. And at the same time, I want to acknowledge there's a tension between, on the one hand, focusing on the interpersonal, on the other, on the structural. And that's a tension that's epitomized by anti-racist work itself and also restorative justice work. Ibram Kendi, who's the best-selling author of Stamped from the Beginning and How to Be an Anti-Racist, recently founded a university center on anti-racist research, and it has as its watchwords, racial inequity is a problem of bad policy, not bad people. And yet Kendi himself chose as the banner for his own biographical page, being an anti-racist requires persistent self-awareness, constant self-criticism, and regular self-examination. That personal and interpersonal focus on the one hand, and the recognition of policy and structure on the others, that's a tension. And I suggest that it could be a creative tension that in fact drew the interest of some great thinkers through history. Think about French philosopher Jean-Paul Sartre. He proposed combining the structural analysis of Karl Marx's historical materialism with the existential psychoanalysis of Soren Kierkegaard. He argued that action and social analysis both need to understand the modes of economic production and that dominate society, and also the latitude each individual has for action, for freedom. Other thinkers have grappled too with this issue of individual choice and structure. W.E.B. Du Bois, distinguished sociologist, for example, exposed through empirical research the false assumptions prevailing among sociologists in the 1920s about the causes of poverty and racial inequality. And he showed how patterns of exclusion and violence, rather than some kind of personal inferiority, contributed to the impoverishment and criminal prosecutions of African Americans, while demonstrating the agency of individual African Americans. Law professor Catherine McKinnon crafted the idea of sexual harassment to name and challenge the abusive and hostile treatment of people at work simply because of their gender. And in so doing, she illuminated patterns of conduct that are condoned and permitted by individual employers and co-workers and may seem to be simply interpersonal, but reflect much larger structures in society. At its best, advocacy for civil rights connects the dots to make clear the underlying systemic patterns and also the distributed individual choices for racial discrimination and disadvantage. There are interesting anti-discrimination efforts that try to connect the dots in just this way, that tackle patterns of exclusion and negative workplace treatment. For example, Home Depot installed a promotion and hiring system that bypasses managers and their possible biases by automatically submitting an individual's application for a new job or promotion based simply on that individual's stated preference and objective qualifications. There's much to learn from individuals who connect the dots. A recent example, after serving 9 years in the Federal Equal Employment Opportunity Commission, Chai Feldblum decided not to return to her prior role as a law professor focused on anti-discrimination, and instead she made the surprising move of joining an employer-side private law firm to build a brand new center on workplace culture consulting. She had concluded through her years of litigation and legislation that until specific workplace cultures are changed, there will continue to be issues of gender and racial discrimination and hostility. Changing the systems and changing hearts and minds, both are needed for racial justice and for restorative justice. I think back to the case of Michael Lee, who killed philosophy professor Young Kim, and the experience of Mercedes, who stole shoes from a high school classmate. In both instances, restorative justice helped the individuals facing sanctions communicate and apologize and be seen as human beings by those that they had harmed, and the life trajectories of those immediately affected changed. But the broader promise of restorative justice is to draw in not just those immediately involved, but the concentric circles of people implicated by such incidents. The violations of law and harm to people occur because of the confluence of individuals, the incentives of organizations, and drawing in people besides those immediately affected could make a difference. What about the landlord who was about to evict Matthew Lee? What about the welfare staff member who would decide whether to return the other children to the home of Mercedes and her mother? What about bringing in other resources in the community and hearing multiple points of view about what could be devised going forward, and having a broader conception of responsibility Rather than signaling just who or what immediately caused a violation or a harm, responsibility points to who or what contributed at all stages and who may now have the ability to respond. It is, after all, called responsibility, isn't it? And extending the exploration to include employers and community members and others, if done right, restorative justice could actually lead to prevention in a much deeper way than simply putting the burden on individuals to manage their emotions, important as that may be. Restorative justice invites hope. Focusing on the future helps. I'm given hope by looking at interesting new innovations and organizations, one called Circles and Ciphers that's led by and for young people using art and education and direct action to advance personal healing and also to challenge the systems that produce mass incarceration. Reimagine LA County is a collection of activist groups that invest monies in social services rather than criminal law systems. Safe Space Radio offers beautifully produced radio interviews and advice as a kind of public health response to individual and community trauma. And embracing restorative justice approaches at a national level, Canada settled its largest class action in its history, a challenge to the abusive treatment of children by the Indian residential schools. And as part of the settlement, created a Truth and Reconciliation Commission of Canada. Canada then spent 6 years and 72 million Canadian dollars to support truth-telling and reconciliation among former students and their families and communities, and indeed all Canadians, with events held across the country, engaging the public and educating the public, producing a 6-volume final report, and 94 calls to action. As of last year, 10 of those calls have been completed, 21 are in progress with projects underway, 37 are in progress with projects that are proposed, and then there are 26 still to be tackled. Critics have objected that the Canadian Truth and Reconciliation Commission treated the issues as past rather than acknowledging ongoing aspects of colonialism. And critics said that the government priorities dominated more than priorities from the grassroots. It had no power of subpoena. It focused more on testimony from the former students than on the former teachers or the government. But it was quite a remarkable phenomenon in Canada, and a form of restorative justice that connected the dots from individual stories to structural abuses. Central to the learning of an initiative like that is learning to ask the right question. Fania Davis, the restorative justice leader, says, the question now is how we craft a process that brings the healing piece together with the social and racial justice piece, how we heal the racial traumas that keep reenacting. These initiatives that I've described and many others, the Right Question Project is one I'd love to talk with you about. They connect individual with collective action, and they also invite reflection on the tension and limits, the setbacks and the critiques. Poet Audre Lorde powerfully once said that the master's tools can never dismantle the master's house, but maybe new tools can be forged. Maybe storytelling, self-criticism, empirical study, group mobilization can combine with legal advocacy and politics. Looking at restorative justice and anti-racism together means looking at unfinished business, but also at tools that can help. Thank you.
Thank you, Professor Minnow. There would be uproarious and deafening applause at this point, but of course we're in this strange Zoom world, so there's a momentary gap. But thank you so much for your talk tonight. There have been questions coming in through the Q&A feature, and I'll ask a couple to get us started, and also remind attendees that please do use the Q&A feature to write your questions. And the other thing I will mention too, as folks are thinking of questions and or taking a moment to type their questions, for those of you who are interested in reading a published version of Professor Minow's lecture, it will be published in the forthcoming issue of the Nevada Law Journal. Look for volume 22, issue 3 next year. So thank you so much for that. And we've had a couple of questions about recording, and we will be working on making a recording available once we've been able to edit a transcript appropriately. So Professor Minnow, one question to get us going is, so in your talk you focus on tensions between formal and informal systems of justice, tensions between the interpersonal and individual need to enhance justice, but also the structural approaches to enhancing justice. And the question is one source of these tensions the fact that we, as diverse members of a society, may have different and multiple definitions of what constitutes justice and injustice, and hoping you could talk a little bit about that.
It's a wonderful question, and I'm sure that is true. The very use of the word restorative justice, it adds a modifier to justice, suggesting that what else exists is not restorative justice. And trying to identify what are other meanings of justice has really been occupying philosophers and political scientists, lawyers for many years. I think that there's a debate even within one system of justice about what are just results. A kind of folk saying is just us, is justice is just us. But justice, we usually think of as something that's not just us. It's not just what human beings ourselves individually want. We come up with something like a formal legal system to try to install institutions to take care of these tough questions for ourselves. When you introduce more informal processes like alternative dispute resolution and mediation and restorative justice, where people are sitting together and in the midst of talking about a particular conflict, also discussing what would justice mean, you open up all of the issues that otherwise have been taken care of by having a formal legal system. And there's great power and beauty in that, but also new conflicts.
Thank you. Thank you for that. So another question is related to this as well, which is, if there are multiple conceptions of justice, when and how do we choose among them, and who should do the choosing? And I guess, you gave a little bit of the example of an ADR session, whether it be a mediation session or a restorative justice conference of some kind, where the participants are debating different conceptions of justice. Can that happen structurally? Can that become a societal or systemic discussion, or does it have to happen in these kind of piecemeal discussion by discussion settings?
I have to say that it was exactly a question I was grappling with as I was writing, and how to translate from the very local, immediate, face-to-face discussions, some sense of the desires for something that is going to transcend that particular group and become part of a societal response to injustice. I don't have an answer. I have some stories to tell. So this is shifting gears a little bit from crime or even the disciplinary problems in schools, but it's an example of going from the very local to the more systemic. So I was working for a social service agency that one week had such a flood of calls to the hotline. It turned out that people were not receiving their social support checks from the state. And there was very little the agency could do. It didn't have a lot of resources, and it was also swamped. The hotline couldn't even answer all of the calls. An unusual decision. Somebody at the hotline said, let's accelerate this to the board. And they brought the fact of this problem to the board, which included people from leading corporations and nonprofits in the city. And those people in turn went to their staffs at their offices and said, let's put together a SWAT team to go to the State House and figure out what the problem is in getting the checks out on time. And they did that. Now, I don't know why we can't do something like that more often. I don't know what the exact translation of that is in the justice system, but that seems to me such a great example about the disconnect between what people are seeing on the front end and what people with knowledge and resources in other rooms are doing. And we need to actually connect the dots.
Thank you. So there's a question in the chat, and I think and a couple of comments in the chat too, and I think they relate to a larger theme, which is, could a restorative justice model work within our pre-existing established formal justice system? What would that look like? And is it possible to kind of to tinker and retool within our current system? Or is the historic racism and injustice so deep that the structure, that the system itself is the problem, and we need to scrap it all and start from scratch? And so there are just a couple comments and questions asking you to kind of talk about how do we, is reform and kind of incremental change by introducing something like restorative justice, is that realistic?
I do think that this is finally a moment of reckoning in this country. We, the most incarcerating nation in the history of the planet. And I am struck by the fact that other societies at other times have also had moments of reckoning, and if you will, a reset moment. A time when, in fact, mass amnesties have been created and mass forgiveness of debts. And I'm wondering if we need a reset. In a small way, President Obama tried to do this by having a commission look at those people who were incarcerated under criminal laws that had since been changed to have decriminalization or shorter sentences. And he actually granted pardons to those people. But that was a limited group of people. And many would say, you know, you look at the reliance on eyewitness testimony that's flawed, on coerced testimony, on manufactured evidence. There's so much that has been problematic. On the other hand, you can't throw out a criminal justice system without having something else. And I am very struck by work by people like my colleague, Randy Kennedy, who says, you know, poor Black communities are the most victimized by crime. They're not helped if you trash the criminal justice system and destroy it without something in its place. So I guess this is another instance of both and. I think that we need massive restart and structural reform, whether it's through revising the substantive rules of sentencing and criminal law, or electing progressive prosecutors who just decide that they're not going to prosecute at the same kind of bases that people have in the past, and they're going to promote people based on using alternatives like restorative justice. That would be a big change, rather than promoting people based on how many convictions they got. So I think we need massive structural changes, but I also think that encouraging these experiments is very important. You know, it's kind of like building the scaffold around a building while you're trying to renovate the building. So can we build the scaffold so that when we tear down more of the building, we actually have started to build a new one? That's the way that I think about it.
Thank you. So here's a question, shifting gears a little bit. And the question asks, or notes that the centrality of lawyers to litigation-centered forms of justice is evident. And the questioner asks whether you could offer perspective on the role, or perhaps the limits on the role, of lawyers in restorative justice processes, and whether that's in the design or in the implementation of restorative processes.
Well, not if they've been trained at UNLV. I mean, it all depends on what kind of training the lawyers have, but it is certainly the case that too many lawyers, I think, assumed an adversarial posture when it comes to any kind of conflict resolution. I spent an earlier part of my life working in family law and often found that the lawyers were more antagonistic than the parties were. And so I think that there is a danger of a kind of adversariness for many lawyers, but there are other lawyers who actually are very gifted in devising processes that are constructive and forward-looking. I have a good friend who's a mediator and who constantly comes up with ways to frame a question that helps people find the common ground or find a way to grow the pot. So I don't think that it's necessarily an occupational hazard. I think it depends, as is always true about any question about law. That said, I think that there are many people who don't have legal training, who don't have advanced classroom training at all, who are gifted as mediators and talented in restorative justice. And that's why I made the reference to the risk that when a new system like restorative justice starts to build credentials, there's a risk of reinstantiating old forms of privilege and failing to recognize other kinds of value and recognition. And in this instance, it may have a real racial impact.
Thank you. So a couple of questions too, also kind of different variations on a common theme, which have to do with compelling people to participate in restorative justice processes. So, on the one hand, how do you incentivize people who would benefit from restorative justice to participate? But at the same time, what's the harm that people might not consent to or truly consent and buy into the restorative justice process, particularly those who may have done a harm? And how can that tension be navigated?
It is a huge tension, and the short answer is there is no real free choice for someone whose alternative is a coercive system. It's about the degrees of freedom, but it's not actual freedom. I guess I do think giving people information about what the options entail and as much honesty as possible about not just the processes, but the sanctions and the patterns, what happens to people who go that route as opposed to people who plea bargain. But I think other than helping individuals ask questions about what's involved in going through the process and saying, well, here's the alternative if you don't do it, it's not going to be a free choice if the alternative is going to court or the alternative is suspension from school. One reason I'm so intrigued, though, by the whole school approach for schools that have really embraced restorative justice is that it's not like a new moment when someone's introduced to, okay, here's the restorative justice process. They've learned about it from the get-go. They've had classes about it. They've talked and done role plays. They've participated in restorative justice activities. For many schools that have embraced restorative justice, probably the best beneficiaries are the students who are repeat players in the sense of running these circles and developing dispute resolution skills themselves. And they become very mature and learn a great deal. And I think actually finding ways that people who themselves are often identified as quote unquote troublemakers, that they can become leaders, they can become trained in these, that can be a tremendous resource for them in the rest of their lives and for the community. So I think that if restorative justice isn't, for the first time introduced, now that you have been arrested, you have the option of a restorative justice process, but instead becomes more mainstream, I think that that's a better bet. And there are avenues. I mean, one reason that I wanted to talk about the role of media in the contemporary anti-racism work is that media is a very, very powerful tool. And if we had, movies and TV shows that actually depicted restorative justice, it would be more familiar. The phrase designated driver was invented by people at the public health school at Harvard. And they identified as a measure of success, when would that phrase appear in the dictionary? And their method of getting it in the dictionary was to talk with people in Hollywood and to get as many shows to use the phrase as possible. So I think that that's something that restorative justice ought to be thinking about.
Thank you. So here's a question that I think continues to build upon the previous question and your most recent response. And so it says, you know, in your talk, you discussed the stories of Lee and Mercedes and how their crimes were related to underlying structural issues, lack of funds for basic needs, housing, healthcare. And the question asks, do you think restorative justice is a process that focuses on symptoms of problems rather than the root? Is there the potential also to do this kind of more structural root cause, and addressing those root causes of problems, and if those things are in tension, then how can they be reconciled?
Well, thank you for that question. And I do believe that there is that potential for something more systemic and structural in restorative justice, but not the way it's usually conducted. So even the Truth and Reconciliation Commission in South Africa, that for many people is the touchstone for the restorative justice initiatives that we know, even that was nationwide, even that talked about whole sectors that were contributing to apartheid. And yet when the time came for testimony by the judiciary, for example, the judges didn't come to testify. When the time came for testimony by the corporations didn't come to testify. And when the time came for reparations, the TRC recommended reparations and the parliament did not approve them, even though it was dominated by the African National Congress. So this great example of restorative justice did not tackle the structural issues in any systematic way. I'm interested in the Canadian experience. It's, you know, the jury's out, but they seem to have more resolve to connect to something more structural. We'll see what happens.
Thank you. So here's a question kind of riffing and again, building on your previous comment about the media and the role of the media in, you know, popularizing kind of new concepts like the designated driver. So this is from one of our law students who said, you know, recently in a Law and Order SVU episode, there was a portrayal of restorative justice diversions as a negative for people who had been harmed. So people who are, you know, characterized as victims of crime. So how do you recommend addressing those negative portrayals in the media? And I might also add, just as my own little coda to that, if you think about the popular media portrayals of mediation, they're abominable, right? So if you could talk a little bit about the work that could be done in that area.
Same thing. Well, you know, it's not as though there's nothing to it. There are negative examples of ADR and there are negative examples of restorative justice. But I think that the larger question is, are there positive examples in reality that deserve depiction? And the answer is yes. And I think I actually participated in a fascinating all-day experience bringing together 50 academic experts with 50 Hollywood writers and producers to see if more research ideas could make their way into Hollywood and into films and into indie productions. And I think we need much more of that. And what I found, frankly, was hunger on the part of the writers and the producers. They want access. And this was a group that particularly wanted to do anti-racist work. They want to know what the research can tell them. And so I think it's, you know, actually an opportunity for law students to propose script ideas, to make documentary films. I think these are the tools of social change of our time.
Thank you. So here's another question, which is, and maybe this is also an opportunity to compare and contrast a little bit with the experience of, for example, a country like South Africa, which had this huge national restorative justice project. But the question asks, would more widespread introduction of restorative justice in schools, for example, if that becomes widespread, can that fundamentally change the way can we as a society approach justice? Were such changes evident in South Africa? Was the experience after the Restorative Justice Project in South Africa, was there a change in the kind of societal national conception of justice and justice? Was there any kind of coalescing or a precipitation of new views and new ideas about justice or injustice as a result of this national project?
I think that the dominant answer has to be no. South Africa, after the Truth and Reconciliation Commission, unfortunately has had a period of serious violence, and particularly in the poorest communities, and very, very troubling patterns of criminal law. But at the same time, there are small efforts. The schools do use the Truth and Reconciliation Commission materials. There have been many movies that have been made about them. It's well known to people. But did it alter patterns of violence in the country? Unfortunately, no. And it really goes to what Fania Davis describes. If the underlying traumas are there, people will replicate them. I was once approached, it really haunts me, by a group in Northern Ireland who noticed that I had done work both on these societal restorative justice issues and also on child abuse. And they said that they hadn't seen people put those together, but that they had very high rates of child abuse and actually domestic violence in Northern Ireland. And also, of course, they had had societal troubles of a serious sort. Well, there's something similar, at least for a time, South Africa had the highest rape rate of any country in the world. And there are connections between societal traumas and interpersonal traumas. Very haunting to think about that and to think about how do you undo those patterns. But that said, I'll tell you, I did work in former Yugoslavia where it was very interesting to find that people really couldn't be in a room together with people they identified as from another group until there was some, conflict resolution training, just giving people some basic skills about how do you sit in a room and have a meeting with someone that you disagree with. And on that, I am reminded over and over again of a story about South Africa. So the idea of reconciliation is there in the title of the Truth and Reconciliation Commission, even more than restorative. It implies somehow coming together in either a religious sense or something very deep. And I asked the vice chair of the TRC in South Africa, what did it mean to him? Because the chair, Archbishop Tutu, was very clear that to him it was a very religious, a thick idea of reconciliation, that in God we all come together. Well, the vice chair, also a minister, said that was not his view at all. And he said that for him, a white man, but one very involved in the African National Congress, that if he's walking down the street and he sees coming towards him someone who was in the secret police, and they recognize each other. He said reconciliation is walking past each other down the street without getting into a fight. And that conception of reconciliation I can live with. I think it may be more accurately described as coexistence, but in many places in former Yugoslavia, that is progress. In many schools, that is progress. And giving people some basic skills about how can you coexist. How can you manage your own feelings? How can you come up with some rules about using space and time? That's, I think, a step forward.
Excellent. Thank you. Well, so I'm keeping my eye on the time here, and we perhaps have time for one more question here. And this is actually one of the earlier questions that was asked. And again, I think it builds on what you just said, Professor Minow. The comment says, Dr. Martin Luther King Jr. said, "Riot is the language of the unheard." And the Kerner report seems to highlight a similar reason for the unrest that arose around the time of that report. And so what are a few key things that we must remember to teach our brothers and sisters when we're called on for our skills in the conflict resolution and legal space to ensure that those who are doing the work to address issues from a restorative justice and anti-racist perspective do this work in a manner that allows all groups in conflict to work together to achieve results?
Well, that's so eloquently put. I think it certainly helps to start by recognizing that conflict is not always bad, that conflict itself can be expressive of a conception of justice. I also think finding ways to signal that you're an ally to the larger causes of tackling systemic injustices, that can help. But we're going to be in this mess for a long, long time. And it's not going to all go away by people saying, oh, let's just all get along. And so I think that finding ways to actually be honest about where we have deep divisions and to put a human face on someone that we really disagree with. And that to recognize that as a virtue and to actually teach young people to do that. We need to work very, very hard on that. And it's one reason I'm right now involved in various projects and just helping people who don't know anyone like each other to talk with each other and just hear each other and see if it's possible to recognize the humanity in each one. But that said, again, I just don't think we're all going to hold hands and get along. There are structural problems in this country, as there are around the world. The pandemic is revealing it. I mean, in my own city, you know, the rates of access to the vaccine are very high in the white community, and they're half as high in the Black community. I mean, the pandemic is like a flashlight shining on all the holes in our society. And it's a call to action. What are we going to do about it?
Thank you. So what I'm hearing you say is that there is future work at the Sultan Center for Conflict Resolution.
That's correct.
That we have more work to do and a long road ahead. Well, we have been pestering you with questions, Professor Minnow, and picking your brain. And I know you're on the East Coast, so it is certainly later there for you than those of us who are chiming in from the Pacific time zone. But I do just want to thank you so much for your time, for your remarks. As I mentioned, we are looking forward to reading your published lecture in a forthcoming Nevada Law Journal issue. And I'm giving a round of applause to you and thanking you again and thanking all of our attendees for all of your excellent questions and your time and attention over the past hour and a half plus. And I think with that, we will call it a night. So
thank you so much.
Thank you.